Madam Deputy President.
Honourable Adam Searle.
Thank you, Madam Deputy President. I wish to concur with the observations made by the Chair of the Committee, the Honourable Robert Borsak. I won't elaborate on the findings and recommendations, but I think it can truthfully be said that this was a committee that tried to come to grips with very substantial public policy issues, as well as a live controversy that had been unresolved by the institutions of the state for more than a decade, and it was a complete disgrace that this matter was not able to be adequately or properly resolved. I also acknowledge that what it also showed is that the overlapping responsibilities for police oversight of a number of bodies did contribute to that problem. In particular, the non-cooperation elaborated on in the report by the Crime Commission with the Strike Force Emblems, thereby completely stymieing that police investigation, was not only unfortunate, but it seems to me a situation that should not arise again, that a properly constituted investigation by the New South Wales Police can be brought to a complete halt by the non-cooperation of any agency of the state, much less one of the importance and significance of the New South Wales Crime Commission. It's not only unfortunate, but it must never, ever happen again. I acknowledge also the contribution of the Honourable Trevor Cunn. I agree with a lot of what he has said, particularly about the conduct of the committee and the committee members, and the way in which we worked, I think, diligently and mostly cooperatively to reach the recommendations. I acknowledge that interjection, at least respectfully, to come to terms with the information that we had to make some kind of sense of it and to make some sensible findings and recommendations. And I think the process and the outcome of this committee and its report, I think, are a high watermark of the operation of the committees of this Parliament. However, I do think there are legitimate criticisms that can be made of the conduct of the former Ombudsman and his office in undertaking the two inquiries that were given to that office. I won't elaborate upon those criticisms because I think they're dealt with in detail in another committee, the progress of the Ombudsman's investigation, Operation Prospect, undertaken by General Purpose Standing Committee number 4, which included 5 of the same committee members of this same committee. But nevertheless, I think it can be said through, and this comes through in the submissions made by the former Ombudsman, as well as in his evidence given to the committees. It was quite clear that the former Ombudsman did not welcome scrutiny of his office or of himself or of his officers in the way in which they have undertaken the charge given to them by the Parliament. And I think that's, to put it mildly. The office of the Ombudsman plays a very important role in this state. It is to inquire into and to shine a light on aspects of government administration that governments of the day do not readily welcome. And that's appropriate, and that is the role of the Ombudsman. But we had here this enormous controversy, which was, of course, of a huge significance to the persons who were the subject of those warrants, which on the material before the committee seemed to be at least improperly issued, and in my own view, quite likely unlawfully issued. And it's not only a significance of the people who were caught up in that. Of course, it was given a lot of currency by the fact that a person engaged in at least in part of the operation that led to the issuing of those warrants was a deputy commissioner, is now a deputy commissioner of police, and that one of the people who was the subject of that, of at least one of the warrants, possibly more, in fact definitely more, was another current Deputy Commissioner of Police. And the fact that makes this issue so pressing is this is not just some old wound that hadn't been healed. It was a live controversy that, on the information that was quite apparent, was impeding at least the smooth, if not the effective, operation of the top echelon of the New South Wales police force in this state. That 2 of the 3 most senior police officers in this state were clearly in a state of non-cooperation, if I can at least put it in that neutral term, and probably much worse. The fact is that this is a matter that was well and truly overdue to be addressed, and we did our best to get into that, as well as to the Ombudsman's conduct. And finding number 10 is enormously important, because it was quite clear that the New South Wales Ombudsman should not have incorporated both the legality of the warrants and the leaking of confidential information into a single inquiry, and that so doing had resulted in participants, whether they were complainants or alleged perpetrators, it had delayed the completion of the inquiry, an inquiry that has now, I think, cost some $6 million, has taken 3 years, in fact, has taken longer to conduct than the original operations that were at the heart of this inquiry. I will, in the time left to me, dwell on what I regard as, I think, the most important aspect that we deliberated upon, and that is that the application and the supporting affidavit for listening device warrant 266/2000, that is the Bell warrant, did not appear to provide the necessary facts and grounds to justify 46 of the 114 people having their private conversations listened to and or recorded. Now, as the previous speaker identified, we only had a couple of these documents before us, but what was quite clear is that they were cut and paste jobs that were rolled over every few months, and maybe many of the flaws that we saw were as a result of that cutting and pasting and just accumulation of names in these rolling warrants. But recommendation 1, and I think it's important that it is recommendation 1 of the committee, was that the New South Wales Government should establish an open and independent inquiry to review the current system for granting surveillance device warrants to ensure compliance, the integrity of the system, and other matters that I won't presently go into. It's quite clear that this needs to be done to enhance the integrity of the process and to restore public confidence. And it's unfortunate that the government hasn't responded. Now, I know the government hasn't responded to this inquiry because the executive takes the view that the inquiry is now defunct, either when it delivered its report or because of the prorogation of the Parliament, and they will respond to the second inquiry, the one conducted by GPSC number 4. But I think this matter is quite pressing and it needs urgent action. I note that in a news article from earlier this year, it's now clear that New South Wales Supreme Court judges are required to give written reasons for issuing warrants authorising covert surveillance, such as listening devices, and that these written reasons are placed in a sealed envelope alongside court documents. This was as a result of the action, as I understand it from the news article of May 13, 2015 in the Sydney Morning Herald, of current Chief Justice of the New South Wales Supreme Court, Bathurst. Now, I think this is a good initiative, that reasons be formulated and attached to the court documents, but what we don't know is how or in what circumstances they can be accessed, or whether they can be legally accessed in circumstances where there is a subsequent challenge to the warrant. That is implicit in judges doing this work now being required to effectively give reasons, although those reasons, of course, are not public. I think the inquiry into the system of surveillance device warrants and intercept warrants generally needs to be undertaken. I know one of the other recommendations was for a unified police oversight body. The government, rather than leaving that to the Law and Justice Committee, has commissioned former Shadow Minister for Police and Attorney General, Mr Tink, to undertake that. I believe Mr Tink has delivered his report to the government. I look forward to seeing that. That work is very important, but I think there is a really pressing need to overhaul and to review the system of the granting of surveillance devices in this state.